some of the questions that, frequently come to me are, for example, you have a business owner, they have started their own business, they've been running it for maybe 10, 15, 20 years, and they are perhaps the sole shareholder, or there are other family members who also own shares, or perhaps there's a partner. But in any case, they own, let's say a majority of the shares of this privately held Canadian corporation. And let's just say it's worth somewhere in the range of $5 to $10 million. We'll just say 5 million. What are some of the considerations that you would look at when you're advising this client?
Yeah, I mean, there are a couple of different ways of looking at this too, because the first question is, what are your plans with the business? Are you looking at hanging on to this long term? Are you looking at selling in 2 to 5 years? And so looking at the person's plans for how they want to deal with the shares, because of course, the shareholders are the owners of the business. Some of the shareholders may or may not be involved in the business. So estate planning gets rolled into this in addition to the corporate structuring side of it. So if you're involved in the business and you own shares, or if you're not involved in the business and you own shares, first step is you want to have a shareholder agreement in place that dictates what everyone's doing in that business. And the second thing is what happens to the shares after you pass away, or if you get divorced and the shares go to your ex, or if you get into a dispute with your other shareholders. So starting point is always, shareholder agreement's a good place to go. You might want to consider having a secondary or corporate will to address the shares after you pass away, because you can bypass a whole other layer of tax. That happens at the provincial layer, the estate administration tax layer, but there's also an income tax liability, which is federal. So looking into those issues is important for planning purposes. Maybe you want to succeed these shares or the business to your family, and that's where a family trust can come in, and it can allow you to mitigate any tax liability, income tax liability that happens on your death by doing what's called a rollover, where you trade in your shares, you give your shares to your family members, and you take back fixed value shares so that any growth value happens in the hands of your beneficiaries. So when you pass away, that mitigates your tax consequence. So there are a couple of, it's very fact specific. That's the thing about taxes, it's very fact specific. In fact, if you look at the Income Tax Act, it is like 3 phone books. I don't know if anyone remembers phone books anymore. Nobody uses phone books anymore, but They were big, thick things. And the Income Tax Act could stop bullets. And so it's by far the longest statute on the books, by head and shoulders way above anybody else. And the reason for that is because they don't want any interpretation by the courts. The courts are only there to fill in gaps. So if you have a very comprehensive statute, it makes it hard for the courts to fill in those gaps. So they want to make sure every rule is covered. So if you have all that covered in this law, and we know what we can do within it, we do our best to try and mitigate those consequences and make sure that you're aware of what they are before they happen. And it helps us plan better too.